Okay, we're ready to begin. It's 1:30. I'll ask you if you have your cell phones to do the same. Make sure they're on silent or vibrate, turn them off. Okay, has the board members had a chance to review the minutes of our previous meeting on Monday, February the 2nd?
I'd like to make a motion that the minutes be approved from our February 2nd meeting.
Second. Okay, motion made and seconded to approve the minutes as presented from February the 2nd. Ms. Guerrero, did you say you had an additional
Yes, sir.
change to those minutes?
I do indeed. Rebecca Guerra, Planning Manager for the record. I have two corrections on page 15. On page 15, I need to make a correction on the 5th paragraph from the bottom. I would like to change the name Mr. Wardlaw to Mr. Nolan. As the chairman, that was your action that had to be taken. And then again on page 17, there was a blank on referring to a Mr. That individual is Mr. Nolan. Again, so I have those two corrections to make. So if you approve the minutes from February 2nd, I'd like you to do so with your permission with those two corrections.
What I'll do is I would withdraw my motion to approve the minutes as accepted and make a new motion to approve the minutes with necessary corrections.
Second. Okay, motion made and seconded to approve the minutes as written with the necessary corrections. All those in favor, raise your hand. Unanimous. May I have a motion? I'm sorry. We're on item 3, the consideration and adoption of a written decision on the appeal of case ZBA 14-41 and appeal by Jesse Martinez, Chris Cornell, Dennis Grafa, and H.R. Wardlaw. No, I didn't say that. Dated October 31st, 2014, and directing that the written decision be filed in the board's office with the record of appeal. Patrick Howard proposed drafts of the board's decision are before you that have been submitted by interested parties to the board for its consideration. Number 1, submission from H.R. Wardlaw III received February 18th, 2015. 2, submission from Samuel Adam, attorney for Lee Pfluger, received March 31st, 2015. 3, submission from Samuel Adam, attorney for Lee Pfluger, received May 1st, 2015. The board may deliberate regarding these submissions and the approved minutes of the hearing on appeal. The board may consider a motion for adoption of any one of these variations as submitted or as modified by the board as its written decision on the appeal. Would anyone like to begin? Mr. Wardlaw? Do you have something you wanted to say?
Yes, I sure do. For the record, my name is H.R. Wardlaw III. I'm one of the appellants in this case. After we had our hearing, I drafted, as is customary, a decision for you to enter, and I sent that in immediately. The decision that I have drafted narrowly tailors itself to a motion made by Mr. Fred Adams and seconded by Jim Turner and voted on unanimously by you, the board members. That is the only issue that was in this case that was tried. We had a narrow appeal, which was in writing, made by the appellants, and the only issue in this case to begin with, and at any point in time, was whether or not the proposed silica frac sand operation of Mr. Pfluger and his company fit under definition of light manufacturing under the zoning ordinance of the city of San Angelo. You determined that it was not a permitted use under light manufacturing, and that's the only issue in this case. So that's the way the decision needs to read, and that's the way I prepared it. Subsequent to that time, Mr. Allen has created two more drafts. The first one, he says in there, he takes my language and then he adds on, and that the transloading and storage of products used in the oil and gas industry other than frac sand is a permitted use. Number one, what other products in the oil and gas industry involved was never a part of this case. You, the ZBA members, do not have any authority or jurisdiction to be making a decision on hypothetical situations that weren't before this board. And that's certainly a hypothetical situation. And it does not make any sense from a common sense standpoint. You would be ruling that products used in the oil and gas industry are permitted uses. There are all kinds of dangerous products used in the oil and gas industry, and in particular fracking and other things that might not be permitted under our zoning ordinance. So you don't have the authority to do that, and with all respect, and I'm asking you not to do that. And here again, I'm the prevailing party, and I'm entitled to submit my draft for your consideration. The losing party is not supposed to submit his draft to have you overturn what I've come up with. But even it gets even worse. If you look, he finally throws my draft in the trash can, and he totally comes up with a new draft and uses language permitting all of this stuff that weren't even a part of this case. And that's just wrong, and you're not supposed to get into that. You do not have the jurisdiction. You do not have the authority. I discussed this a minute ago with Mr. Allen, and the only way you can, in Texas, that you can just consider hypothetical situations, or you can't consider any of them unless there's a justiciable controversy, and that's under the Declaratory Judgment Act of the state of Texas, and there has to be a judicial controversy between two parties as to the facts. And there's no issue here as to other petroleum products before it. And under the Declaratory Judgment Act of the state of Texas, those have to be brought under court of record. They're nearly always brought in front of district court. So he's asking you to get far afield and to try to bless something that might come up later on. And I don't think you want to do this, but I just tell you, looking you straight in the eye, you do not have the jurisdiction or the legal authority to pass on something that was not a part of this appeal. And so I really ask you strongly to sign my decision, declaration that I have prepared. It's right on track, and disregard these other two, and let the prevailing parties prevail in this case, and not have it reversed on us at the 11th hour. Does anybody have any questions?
We'll get back to you in just a minute.
You what?
So we'll get back to you in just a minute. I think we'll hear what Mr. Allen has to say. And
Sure, and I have the original ready to present to you to sign if you so choose. Thank you.
okay, thank you, Mr. Wardlaw. Mr. Allen?
Good afternoon, board members. The appeal, which was heard, contested a prior determination of planning. There were actually two letters. One was the August 11th letter, which approved the proposed use. If the board will recall, Mr. Fluger submitted a request through the city's online zoning verification form. It's a service provided by the city, as Mr. Howard testified. He asked for verification of the use of the property, and what he asked to be verified was transloading and storage of products, goods in the oil and gas industry. Mr. Howard's letter came out and used that language. When he was questioned by the appellants, then Mr. Howard reaffirmed that was in fact the case. And the word frac sand doesn't appear in there. Obviously, that was the issue, and the ruling was that that determination was reversed with regard to frac sand only. Now, the record, I have a copy of I have a video of the 2 minutes where that was deliberated and moved on. It's clear what the intent is, but what Mr. Pfluger has not received has been the verification which he requested, which the city provides to its citizens. What my objection to Mr. Wardlaw's proposed ruling is that it leaves the question unaddressed. The process began with Mr. Pfluger's request that transloading of oil and gas products be an approved use, and it has not stopped. That has not been ruled on or verified. With regard to this board's jurisdiction, it's very clear in the ordinance what it is. It says that under section ordinance 2.07062, if someone alleges an error in a determination made by an administrative official, they bring that, and then if you exercise your authority to act on that, you have three options: reverse or affirm in whole or in part, or modify. But it says, and this is specifically reading from subsection B, the board has the same authority as the administrative official. Now, practically, what I ask you to do is to make sure that the end result of this proceeding that we've all thought about and been very emotional about does not create additional controversy in the future. We're some 90 days past, we remember what was said, but 5 years from now, or 10, when the zoning and the ruling of this board may not be as fresh in the minds of us, then what are we left to decide what it was the approved ruling? So I think it's important for this board to specify what was reversed and then what was left alone. If you don't do that, then you have not reversed in part, which was your vote. You've only struck out a part and you have to specify what is left. My second suggestion to you is what could possibly be the harm of specifying and being clear in ruling. In rulings and judgments of many tribunals, when there's an appeal, court and the tribunals are very clear to state not only what's changed, but what's left alone, and so people don't have to guess it. We've got so much invested here, I think that's only fair. When I received Mr. Wardlaw's proposed ruling, Mr. Pfluger and I looked at it, we proposed the smallest change we thought that would be fair and in compliance with the ordinance. We submitted that, it was rejected. When we didn't hear anything further, and I prepared for the prior setting, I put together the materials to put together a decision that completely revamped it to be a format that I thought might be more attractive to the board. But what we're asking is that the original verification be certified, be affirmed, and that all that be reversed is the practice and determination. I have PowerPoint slides that show the original opinion. Shows the excerpt from the YouTube video. It's about 2 minutes that shows what was discussed, and then again discusses the ordinance. I'd be glad to present that. Care to see it?
We'd like to see that.
This is
Excuse me, Mr. Allen. Do we have to admit this as evidence, or is this?
No, this is just considered as argument for,
Okay.
for adopt of your, which format for the decision that you're going to adopt.
Thank you. You can't read the text. I'll have the excerpts blown up in a subsequent slide, but if you have a copy of the last proposed ruling that I sent, this is Exhibit A. And this is the August 11th determination that was made by Mr. Fisher in response to the zoning verification. This is Exhibit A to the second proposed, my second proposed ruling, the one that expands. There are two letters that are attached. Everybody find those?
I found mine.
Okay.
Everybody else? Okay.
This was Mr. Fisher's zoning verification letter that was sent in response to Mr. Blue's request. Here are the two basic components of the ruling, and that is that the property is indeed light manufacturing, and that the transloading and storage of products used in the oil and gas industry is a permitted use. Now, after being requested to change that or verify it, Mr. Patrick Mr. Howard wrote a letter on October 11th, I believe, October 10th, and this is written to Mr. Martinez. Says, I've received your request, and he reaffirms that. This is the actual letter that was the subject of the appeal, as I recall. This was the appellants appealed this letter. And here's the language, and I apologize that it is cloudy, but I think we can read it. And he verifies the proposed use is transloading and storage of products used in the gas industry. He says that it is a light manufacturing zoning, and that the determination in the August 11th letter is verified. Now, frac sand is a small component of that. And so as I understood your ruling, the frac sand was the only part of that that was removed. I believe that there's a section of that here. This is two sections.
Then, no, let me withdraw that motion. Let me withdraw that motion to get my motion together. My motion is to reverse staff's decision as it relates to frac sand and oil and gas products.
No.
So there was the first, Mr. Adams' first motion. And that was confusion over this issue of profits. I think it was late in the day, and I certainly understand that.
So that could be
A lot of things.
You do have to look at the evidence that's presented. I don't think you really had any evidence as to what might be inclusive of the province. So I do think that it's important you consider limiting it to frac sand, since that's the evidence that you received, and that was the dust and other specific information primarily related to the frac sand. And so I was just calling that to your attention as to whether or not your intent would be to prohibit the transloading and storage of all products used in the oil and gas industry, or just the frac sand.
Okay.
Now, forgive me, and I realize I made the slide jump, but that's in there to illustrate that it's a very important distinction, that this is a reversal in part. And I believe that distinction should be borne out in the ruling. So that is the main crux of this video clip, is to demonstrate that that was a discussion and a factor in the determination.
I'm gonna get it right now.
Okay.
I'm gonna withdraw that motion again. If I get it wrong this time, I'm gonna shut the hell up.
You got it.
My motion is to reverse staff's decision as it relates to the frac sand, period. Okay.
Motion made by Mr. Adams and seconded by Mr. Turner to, read that again, Mr. Adams?
It was like,
This is a learning experience, friend.
With reverse staff's decision as it relates to the transloading and storage of frac sand.
That's right. All right, all those in favor, raise your hand. That's unanimous.
that's the end of the clip. So here is the section that I mentioned earlier, this is an appeal under, this is the local government code. This is an appeal of a determination by an administrative official. It is under A1. In exercising your authority, you reverse or affirm in whole or part, or modify, and then make the correct order, requirement, decision, or determination. I think that calls upon you to state whether or not the original determination is valid in your perspective. And so that is why I'm asking you to do that.
Would you repeat that?
It says that you can, in exercising your authority,
Will you speak in the mic? Because
sorry,
we're not hearing you.
in exercising your authority under this appellate section, you have two options. We have three options. Reverse the whole thing, or affirm the whole thing, that's one, or reverse or affirm in part. You also have the option to modify. Now, I don't think that's what you did, but in those instances, the statute says that you have the authority to make the correct order, requirement, decision, or determination. Now, this is from the local government code. The exact language in the ordinance itself, and I have copies here that I'm glad to distribute, says that the board has the same authority as the administrative official in making that, in carrying out that task, in ruling on that appeal. So you have the authority, and I believe it's wise, and in fact I believe it's your ruling, to expressly state that frac sand was the only thing that was reversed, and any other products but frac sand can be transloaded, that are used in the oil and gas industry, can be transloaded on the site. And that rules on the entire determination letter that was made by Mr. Howard.
Wouldn't that already be true, that if we only act on the frac sand, which is what it got narrowed down to very clearly there when the staff was talking about the motion, anything else that's in that thing would still stand? I mean, there's no reason to go back and reinforce it. We're just proving that the frac sand thing stands.
Well, the one might infer that, but this should not be left to inference.
I don't think it, I mean, I don't see that it's an inference. If somebody comes and says, here are the 5 points, you throw one of them out, then the 4 points remain. If he's still got an active letter and the staff's still actively reviewing it, in light of, because the city's changing the ordinance based now on a lot of this stuff. So I'm sort of hesitant to step in and.
You touched on one of my points there, and that is that the city is changing the ordinance, and that factors will change significantly, including city staff, the record that's an official part of the ownership and use of the property. So many things will change, and the people that review this down the road won't have the benefit of that. If it's not clear, then again, it does Mr. Fluger or subsequent owners a disservice by leaving unanswered the question whether the original letter was upheld, with that one exception. So if you'll think down the road, when it comes time to perhaps develop the property, sell it, or whatever might be the purpose, down the road, will a potential buyer be assured that transloading of products used in the oil and gas industry other than frac sand is a proposed use? What would they point to that would be in the records of the city? Should those people have to go through and pull the letters and then pull the YouTube video and then guess at the interpretation of the comments between counsel for the board and Mr. Adams as he formulated his motion? I think that under this, that what this board would be better served to do, or would better serve by doing, would be to clarify, not to be guessed at in the future. Because I understand the effect of your ruling was that everything else in the August 11th letter and the October 10th letter passed through without being affected. In effect, that is an affirmance in part of those sections of the letter. So the other thing is that leaving an unanswered question like this, something to be resolved by inference or by a large undetermined record, invites additional litigation. invites re-examination of the question. It leaves so many things unresolved that this board is charged with resolving. I put two options for you. If the format that Mr. Wardlaw proposes looks best to you, then by all means, if you will add the clause that we requested, that would be fine. Once it came down to doing the work to review all this, I went ahead and drafted another opinion, another decision. If you're in favor of that, by all means, then I'd be glad for you to enter it. One of the main features is that it has the actual letters that are part of the determination process, and those will go in the records of the ZBA and be verified at one stop when someone needs to find out really what was the zoning determination that was made back in 2014. So that's my position on that. I just feel like that it is not in full compliance with the statute or local government code to leave that much to influence and verification.
Where is this information going to be, though? The original route is not going to be in terms of research, I know.
The letters will be in the planning office, as will this board's determination will be in the records and minutes of this official tribunal. The YouTube video won't. I'm not sure that any of the evidence will. And so down the road, if someone wants to know whether, including Mr. Pfluger, I mean, he began this process trying to make sure that he knew what the rules were and to conduct himself in accordance with them. And so that verification process, which he saw, which he provided by the city, will not have taken place. It's left to influence. That's what we really started with. It was not the question, what can I do with this property, but what can I do? And if you reverse and are not specific as to what is not reversed, then you leave that to chance and guessing. I believe that disserves the purpose of having a verification letter so that there's not an issue.
Due to the fact that we don't know what could happen in the future, we didn't even think about frac sand being there. Why would this board want to obligate ourselves to say that anything else can be done there besides frac sand?
Well, that is something that the city provides. The city, through their zoning verification process, gives landowners the ability to ask whether the property they have and a proposed use complies with zoning. And so what you've been asked to do is to say what got decided correctly and what did not get decided correctly. And you leave half of that undetermined. Now, if zoning laws change, then that's a whole other situation. So this action is not binding in regards to future changes in zoning any more than if this hearing had never happened. And one of the things we discussed at the hearing was that we have new proposed ordinances that come about that are being proposed that specifically relate to frac sand. And we were very candid to say that we're not grandfathered in, that we can't claim some kind of exemption because we had a hearing before those ordinances went through. And that's the case with anything else. If the use of railroad cars is by ordinance taken away for light manufacturing, if the transloading of pipe, the transloading of some type of material is excluded by statute, or if a future ordinance outlaws that, the ruling here is not going to affect that. That's going to be binding just as it had been whether we had this hearing or not. So the answer to your question is I don't think that you're tying the city or this board down to any proposed future use. What I'm asking you to do is specify that, except for frac sand, Mr. Howard's determination is correct, that which light manufacturing is an appropriate zoning to transload materials used in the oil and gas industry other than frac sand. Well, the appeal appealed the October 10th letter. Frac sand is not in the body of that. As I recall, the appeal contests the determination made in the operative letter.
May I make a rebuttal?
Hold on a minute. Are you through, Mr. Allen, for the moment?
Yes.
Your turn, Mr. Wardlaw.
Just a quick bunch of points of rebuttal. You're absolutely right.
Into the mic, please.
Thank you.
You're absolutely right. This appeal only had to do with frac sand operations. It did not have to do with anything else in your jurisdiction attaches to the frac sand operation of this particular operation. It does not attach to the entire letter. In fact, the form that the city gives us out to file for our appeal says that you must, with great specificity, disclose what you're appealing. It's not a blanket appeal. You have to focus in on what you're appealing on. We all know what the focus was. We all know what the appeal was. It had to do with the frac sand operations. If you accept Mr. Allen's convoluted theory, and it is convoluted, you would have to, you in fact would be reopening the hearing and the trial that we had on this case, because you made no motions, you made no decisions on other issues in this case, and he's just asking you to piggyback on and add them on. And you don't, under your jurisdiction, under the city ordinances, you have the limited right to rule on the appeal and what is brought out in the appeal, and we didn't appeal the whole letter, we just appealed the fact that they couldn't put a silica frac sand transloading operation on that track. That was the sum and substance of the appeal. And so you can't expand it any. And you don't have a jurisdiction to do that. What he's asking you to do is just like a district court to go under the Declaratory Judgment Act and anticipate things and make rulings on that. And you can't do that. It's not within your jurisdiction. He's just totally wrong. And I can see why he's trying to do it, but he's just wrong. And you know, I know y'all don't want to reopen this hearing. We didn't have any notice of reopening of the hearing. The judgment, the decision that you signed should be specifically confined to the motion that Mr. Adams made and the vote that you guys made. This board didn't make any vote on any decisions about transloading of products in the oil and gas industry. You didn't do that. You would, if you did what he asked, you'd just be reopening this hearing and having a new trial. And I know you don't believe that should be the case. So that's all I had.
Thank you, Mr. Wardlaw.
I believe Mr. Fluker would like to make the
Mr. Fluker?
It's a good time for you.
Mr. Chair, do you want to just open it up for public comment? I know that we had.
I figured I'd public
Do you wanna-
comment. I'm not smart like these guys.
That's fine.
So others maybe follow Mr.
I was
Fluker.
going to go back and forth.
I'll let them go back and forth.
Anyone that wants to speak, we're going to hear them out.
With regard to our argument, if I may, with regard to our argument, if I may, the main point I would make is the evidence that was submitted and complaints that were made by citizens and the appellants dealt with more than simply dust and frac sand. Dealt with vibration, with traffic, and with the location of the parcel. Again, another reason why it was confusing as to just exactly what is being reversed and what is being left. And again, what you arrived at was a reversal in part, and it's unclear where that part is unless you would specify that anything else besides frac sand is approved. So that's my position about it.
Do you want to say something, Mr. Fluker?
Is this public comment?
Sure.
I'm Lee Fluger. I'm the owner of the property at Hill Street. And thank you very much for hopefully bringing this to a conclusion. I have been searching for the last year for clearance and guidance as to what I can do with my property. That's where this all started, was a conversation I had with the planning people and saying, would you help me interpret what the city will allow me to do on this property? I received a letter that specified that the transloading of oil and gas products today was a legitimate use in light manufacturing to be able to go forward with my property. It wasn't as Lewis said, it wasn't just a inference, it was a statement. Then the controversy came up, and legitimately so, it created fear in our community. And in response to that, I deeded my property where it cannot be used for transloading frac sand. At that point, I'm still in search of what I can do with my property. One of our city council people told me, and I will quote, "Lee, you should have come to the city council to ask them what you could have done. Why did you go to the planning department? You should have come to the city council to make that request." I don't know what that course of action is, but that's what I was told. And now I'm in front of you with that same ask. I do not ask to do frac sand there, and I've deed restricted against that. But I do think you are the ultimate answer to my question. And my question is, tell me what I can legitimately do with my property. Now you're asking, what will I do 40 years from now? I'd like to know what I could do with it tomorrow. And I don't think, from Lewis's point of view, I don't think it ought to just be inferred. I think you should give me a definite answer. And if you don't give me a definite answer, then you tell me who I should ask to get a definite answer, which is my right as a citizen to receive response from our city government as to what I can do with my property. And I appreciate your consideration. Thank you very much.
Thank you, sir. Mr. Martinez? You want to ask something, Louis?
I just wanted to ask the attorney, if we're starting, what he's asking, I think is pretty fair and rational. In light of the fact that the frac sand has been removed, and that's not an issue, would not the process be for him to then ask for a endorsement of that original letter, sans the frac sand, or to ask for a new determination on what he could do there from y'all? Or are you not the first place that someone goes to get a ruling on use?
Well, I mean, if there is a question regarding if there's a question regarding what's permitted in a zone, then you would go to the planning department for that, and there would be authority to construe or make a decision regarding application of the ordinance. However, anytime someone's going to utilize their property, they can utilize it for any permitted purpose in their zone. They don't have to come to planning. But this was presented to planning, and so a determination was made, and the appeal was taken from that determination.
So it could be resubmitted for validation of the existing letter sans the frac sand element, or would that need to be done? Would he be
No,
free?
the process from once you adopt a written decision, if there needs to be an interpretation or an application of that decision, or some kind of a change, you would have to go to court for that.
So you mean that Mr. Kluge gets ready to sell this property to somebody, and that person writes y'all and wants to know a determination of what's going to be happening in court?
No,
No.
no. I'm just saying, maybe I'm not understanding your question, but if your question has to do if they want the decision interpreted, that decision's been made and it speaks for itself. And so if a person wanted to make some kind of a change or a clarification or an addition to that decision, and they felt they were entitled to that addition, they would have to go to the court with that addition.
So that would be your advice to Mr. Allen, would be to take it to court.
Can I offer up something as well? Typically what happens is, actually properties are zoned as such, and individuals could take it upon themselves to look at the zoning ordinance and make a determination of what is allowed and not allowed. In those cases, folks are prudent to go to the planning staff and ask, this is my understanding of what I see is allowed. Do you concur or not concur? And we will provide them what we call a zoning verification letter. And this is what's happened in this case. Certainly, subsequent to this meeting today, depending on the outcome of what the decision is, certainly Mr. Flugu could come back to the staff and ask or suggest to the staff that there is certain activity that he wants to undertake, and we can confirm based on our understanding of what the ordinance says, what he can or cannot do, or he can elect to, based on his interpretation of the language, to move forward with some activity if he so chooses. So if that's your question, that's essentially what would happen. So he certainly, the onus could be on him to certainly move forward if he elected to. I think the question was it clear? Is it clear enough based on our discussions of what can or cannot occur on the site? And I think that's probably what needs to be answered in this context.
But there's also the change underlying basis of the zoning that the city council has changed.
Okay, so the change in the zoning is only specifically related to fracking, okay? So, or proppants more specifically, or more expansively. So it doesn't, that's already been clarified, actually based on the decision. The subsequent action by council was based on that, so it doesn't address that specific issue. So we're talking about things other than those related to proppants or frac sand and the like. So we're talking about things other than that.
Mr. Allen.
What I hear as the answer, Mr. Ward, to your question is that Mr. Fluger's next step for determination that the ruling is not clear would be to force him to hire an attorney and file a declaratory judgment action, because the city's already tried to answer the question. And so if the ruling of this board is unclear enough to satisfy, then the only shot he has is to file a brand new lawsuit to determine in an official capacity what your ruling was. We're just asking you to say.
He can actually just resubmit his letter or a similar letter to them to ask about it.
Well, hasn't that already been ruled on?
Yes, and everything else in it still stands. Now and what I'm saying is, if that's the case, and his letter states in all aspects except silica sand, then I'm like David, I don't know why we would want to get into the business of going beyond the silica sand, since that's the narrow field that we were left to in that decision.
Well, I went back through my packet here. Mr. Wardlaw's cover letter and the materials that were submitted with the appeal specifically reference the October 10th letter. And so if someone hired me to prove that some other use was not the approved use, then I would focus on the fact that the whole letter was put before you and only a part of it was resolved. I can tell you from 30 years of law practice that those tiny areas of gray, those shadows, are where crafty lawyers make their fortune. We're simply asking you, since this question began where it should have and has ended here, to simply answer the question. You have reversed in part. So then, are there any other portions of the decision that you also reverse? The answer is no. I see no reason why that shouldn't be put in writing. What you viewed, regardless of what the appeal was, what you viewed was a determination. And the agendas carried that appeal as whether the determination was an error. And at one point, if you'll recall, when we took Frac sand off the table, the appeal continued. We were at the 11th hour, so we made our presentation. The option presented to withdraw the appeal, since Frac sand had been demade or declined. So in that instance, one could say, well, they didn't say anything about the other oil and gas. It wasn't affirmed. So I think that next time that there's some activity on the property, and we'll go in and say that's a violation of the zoning ordinance because it hasn't been addressed. I believe it was addressed. I simply asked you to move that, to put it in writing, put the matter to bed at this point, and not require, just to answer the question and not require additional activity on Mr. Fluke. He's asked the question once, so he should get an answer on all parts.
Yes.
Mr. Chairman, could I say?
Yes, sir.
Lee Fluger, I'm the owner of the property. I would state, Lewis, that to go, I made that same request a year ago. And for this board to say that my proper course of action is to go back what I did a year ago and repeat that and see what happens is not a reasonable choice for a reasonable person. I think if you don't think it's right, I mean, you're going to do whatever you think is right, but I don't see the hesitation if you say, well, by inference, you've affirmed the rest of the letter. And now you're saying, but I don't want to tell anybody that. Well, then I've got to go to somebody who will tell me, and you're a higher board of authority than the planning director. And wherever I go, I have to go, obviously, with this property because it is a controversial property. It's a very difficult property to develop. I don't want to get into another fight with my community and with my neighbors. So I would like to go ahead and find out, get a resolution, and for y'all to, like I say, y'all to tell me, if you're going to tell me, if you're going to tell me, we won't tell you that the other part of his letter is all right, then you tell me where to go that has higher authority than you do to get that answer. But I think I deserve that after a year of working with this thing. And you've been through these processes, San Antonio, everywhere else. You understand how frustrating it is to try to work with a property and then get to a point where somebody says, I don't want to tell you that. You need to go back to square one and try to do it again. That's not reasonable.
Okay, thank you. Mr. Soluri. Taking the decision that Mr. Wardlaw drafted with the addition that Mr. Allen made, and I'll read it. This ruling does, I'm just going to read the addition. This ruling does not modify any other portion of the decision of the planning director, including the determination that the subject property is zoned light manufacturing ML district, and that the transloading and storage of products used in the oil and gas industry, other than frac sand, underlined, is a permitted use. I can't imagine what the oil and gas industry might come up with, but this doesn't obligate, if we were to approve this, this doesn't obligate the board if there was something similar or dangerous to the community for being stopped from being used at this property, would it?
Well, I believe the purpose is for clarification and possibly the concern on the other side is that the statement that and transloading and storage of products used in the oil and gas industry other than frac sand is a permitted use. I don't think you'd be required to make that finding. You could make the finding that this ruling does not modify any other portion of the decision of the planning director, period. So you're just saying we're modifying frac sand, we're not modifying anything else, but you're not going out and making another affirmative statement about use or anything like that, because you didn't have evidence about other uses.
I'm going to assume that that wouldn't be okay with you, Mr. Allen.
Beg your pardon?
I'm going to assume that what he just said would not be okay with you,
Well,
or would it?
Mr. Fluker would be the one that I would turn to ask that question.
Okay, sir.
I don't know if he would like time to answer to that.
I don't, could you repeat that? I'm kind of like,
Come back up, Mr. Fluger.
leaf fluker on the property.
Striking which part again, Mr. Solari? So, the ruling does not modify any other portion of the decision of the planning director, including the determination that the subject property is owned by manufacturing. Get right there.
Is that where the period goes?
Right after director.
Right after director would be a period. Everything else after
This
director.
ruling does not modify any other portion of the decision of the planning director.
Stop there.
Stop that. Is that acceptable?
I was talking here and here and here.
Okay.
Would you read it, please, Mr. Chairman?
Okay, the ruling, the part that was changed, is this letter drafted by Mr. Wardlaw, and this part here added by Mr. Allen. If we just say, this ruling does not modify any other portion of the decision of the planning director, period.
Which is basically the same thing that.
We weren't asked to modify anything else the planning director said, except for frac sand.
We appreciate your consideration of that.
Mr. Wardlaw,
Thank you very much.
what's your opinion of that?
I don't want to get you
You have to
people
go to the
upset.
mic.
Don't get us upset.
But it already says that. It already says that.
Where does it say that? Let's read it together.
Okay. Says zoning board of adjustment in exercise of its appellate authority pursuant to and it cites the sections of government hereby reverses the written decision City of San Angelo dated October 10, 2014 insofar as it relates to the transloading and storage of silica frac sand on the above described tract for the reason that blah blah, which needs to be in there. It says that. It limits it to
Okay,
the reversal. So
they said it'd be okay, we just said one more sentence, just re-saying it, so,
you're saying it again.
well, can we do that, and you be happy? Because they should be happy if we say that.
Yeah, it's bad draftsmanship. If you want to do it, that's fine.
Thank you. So, y'all want to vote real quick, or you want to discuss it some more?
I move that we approve with the changes that you just read.
Second. All right, we got a motion in 2 seconds, we can get it done. All right. Who's kidding? All those in favor, raise your hand and say aye. Aye. All right, that's unanimous.
Thank you very much.
Thank you.